Incorporated today is our National Impact Day of Service. And what a wonderful service this is to talk about elder care and long-term planning care options. And so with that, I would like to introduce our Kent Area Chapter Links Vice President, Gabrielle Whitaker, just to welcome us.
Good morning. Thank you, Tammy. Good morning. As Tammy mentioned, this is tied to a national initiative for us, and we're happy to have Ethan Welch with us today, sharing some information about elder care and long-term care options, which are deep in the hearts of many of us. Ethan is with Hickman and Louder, and we welcome him. And on behalf of the Kent Area Chapter of the Links, I welcome you, Ethan, and we thank you for your time today. I'll hand it back over to Tammy and then Ethan. Thank you all for attending.
Okay, so thank you, Gabrielle. Much appreciation for that lovely welcome. I'm going to just quickly read through Ethan's bio so that you get to know him a little bit better. This information was sent out, but for those who've not had an opportunity to take a look at the brochures and the bio information that was sent out previously, Attorney Ethan Welch is committed to helping families with vulnerable loved ones preserve their resources and plan for the years ahead. His primary areas of focus are elder law, Medicaid planning, and special needs planning. He also practices in the associated areas of estate planning, trust, and estate administration and probate. Ethan's extensive knowledge of elder law and special needs planning ensures that his clients' rights are protected. His compassion and understanding bring his clients peace of mind, and his experience guides them in finding unique solutions as they plan for their future. Ethan is a member of the National Academy of Elder Law Attorneys, the Ohio State Bar Association, and the Cleveland Metropolitan Bar Association. He is also a board member and the treasurer of Council Gardens, an affordable senior housing facility located in Cleveland Heights, Ohio. He finds his work with this organization very rewarding and feels privileged to serve older adults in our community. Ethan graduated magna cum laude from Bowling Green State University and received his law degree from Ohio Northern University. Ethan, his wife, and 2 daughters live in Brecksville, Ohio. Avid sports fans, they enjoy cheering on all Cleveland area teams and exploring the Cuyahoga Valley National Park. That's fabulous. So with that, I would like to introduce again Ethan Welch.
Well, thank you, Tammy, and thank you, Gabrielle. That's a very nice bio that my marketing team put together. You can tell it was done by a marketing team and not an attorney. So I'm very gracious for that. That was a nice introduction. I was pleased to get this invitation to speak to you all this morning about elder law and Medicaid. And I just wanted to first describe, what elder law is. And really, I think of elder law as, an amped up version of estate planning. Estate planning attorneys, they can do typical trusts and wills and powers of attorney, but the elder law component of that is dealing with Medicaid and guardianship and elder law and elder issues with care. So when you hear an elder law attorney, it's a little more involved than just estate planning. So with that being said, I hope to explain a little bit about elder law and Medicaid to you all today. And without further ado, let's just jump right in. All right. So I love this this slide here because it kind of shows, obviously as you get older, more care is involved, and you can see that more money is involved. But that also means that more services are out there to support that care. And you can see, people live at home, and then if they need more assistance, you get caregivers involved, and that could be, paid caregivers, it could be family members, it could be people from the community. And then, sometimes individuals or married couples join a retirement community, and that retirement community can be of many sorts. It could be independent living, it could be, apartments focused for the elderly, those elderly communities that are 55 and up, or a certain age and up. But then when people start to need more care, that's where assisted livings become involved. And assisted livings, they need some help with activities of daily living, but they don't need total care of assistance, kind of like what a nursing home provides. And a nursing home, that is really 24/7 care that a person needs, because they can't bathe themselves anymore. They can't get up and use the bathroom like they used to. So they need that constant care, or they develop dementia or Alzheimer's, and they need, that total watchfulness over them. And obviously when one passes away, that's the next stage of life. So you can see the more money, the more care you need, the more money is involved. And you see that at the very bottom here, the benefits that are available. And, the VA benefits, if you are in if you're in the service, or your spouse was in the service, you might be entitled to some VA benefits. Community services, I think of community services like, your church or your area agency on aging, your community centers with your local cities or villages could provide some care services, Meal on Wheels, stuff like that. Then you have the money component.
Excuse me, Ethan.
Yes.
Excuse me. Are you sharing a video? If you're sharing a PowerPoint, we can't see it. Are you sharing
I'm sorry.
something?
I thought I was screen sharing here.
I can see it.
I can see it.
Oh, I'm sorry. Maybe I just can't see it.
I can see it too.
Yeah, I can see it.
Okay, good. All right. I'm not really sure. But you'll get these slides at the end when I send them to Tammy too. So the main portion of what pays for care as you get older is obviously Medicaid and Medicare. Medicare covers long-term care, but only for a limited purpose. Medicare covers rehabilitation stays at a nursing home after a hospital stay. So think of when someone has a fall and they are admitted to the hospital, they're there for 3 days and they get well enough that they can be discharged. Well, maybe they're not strong enough just yet, and they are discharged to then a rehab facility, which is a wing, typically at a nursing home. They have a rehabilitation wing, or they just have rehabilitation beds that are at a nursing home. Medicare covers that rehabilitation stay, but they only cover for about up to 100 days. And if that person is not improving, then Medicare can kick them off of that insurance. And at that point in time, they either have to be discharged home, or they have to privately pay at the nursing home, or they have to apply for Medicaid. You have those three options once Medicare says that you need to be, terminate off the rehabilitation care that Medicare provides. So that, if you're not ready to go home, or you're just not strong enough, and you need that long-term care component, most people can't afford $10,000 to $15,000 per month, or if they do, it only lasts, a very limited period of time. And that's why many people then apply for Medicaid. So you might say, well, Ethan, how can you apply for Medicaid if I have a house and I have resources, I have money? I can tell you that you can apply for Medicaid. And we can preserve assets. So not all of your money is being spent on the nursing home for your care. We can protect assets. So I'll get into that, how you can protect assets. But let's go over the long-term care Medicaid component of this. So in Ohio, there's 3 long-term care components. There's Passport, which is the in-home Medicaid component, which provides for about 15 to 20 hours of caregiving. You know, Medicaid provides for that, and sometimes that's useful. Sometimes though, it's not enough care. And when it's not enough care, that's where the assisted living or the nursing home would have to be, become involved here. The assisted living Medicaid waiver is limited because not many facilities, assisted living facilities, do accept Medicaid. I would say about 10% of assisted livings accept Medicaid. Assisted livings are much cheaper than nursing homes, but they don't provide that 24/7 care that a nursing home would provide. So it depends on the level of care that this person would need to determine what facility would best suit them. Assisted livings in our area, they have a base amount of money, but then they have add-ons that if you need extra care, then it's an extra amount per month. But I've seen, about $3,000 to $6,000 per month, and memory care units at assisted livings, those are much higher. They're about $7,000 to $9,000 per month. So obviously, the more care involved, the more costly it could become. And then we have the long-term care nursing home component of Medicaid. All 3 of these Medicaids have the same financial eligibility requirements. It just depends on what their level of care is to determine where they fit in of what they should receive. So here's the basics. And this presentation, I could spend a whole day on Medicaid and getting really in depth of the rules. But I'm just going to give you guys the basics, and that way you can generally understand this. If someone is having an issue, well, you can kind of talk them off the ledge that it's not the end of the world, that Medicaid isn't going to be Medicaid doesn't mean that you have to sell your house necessarily or deplete all your assets. So the basics here is you have to have less than $2,000 in your name to be eligible for Medicaid. If a married couple is applying for Medicaid, they also have to have less than, at the same time. If they're both applying for Medicaid at the same time, it's called a dual application. They have to have less than $3,000. The special income level is 27 right now. These numbers, except the resource limit, goes up every year. The special income level is 2742, meaning you have to have less than that level of income to qualify on its face for Medicaid. There's ways of getting around that, though. So if someone has a pension and Social Security together, and that's they're higher than that 2742 level, there's a special trust that we use to get that person qualified. So that's not an end deal, but at the face of this, it's 2742 is the monthly income that person is entitled to receive or should to qualify for Medicaid. And then we have the community spouse resource allowance. That ranges from about $29,000 to $148,000. What that means is when a married couple applies for Medicaid, the community spouse, the spouse that doesn't need Medicaid, they are entitled to anywhere from $29,000 to $148,000 of exempt resources right off the top. Okay, so the way that you calculate that number is you take the countable resources and you divide it in half. And I'll get into what is countable and non-countable, but just easy math here. Let's just say they have $100,000 in the bank in a checking account. I can tell you that's a countable resource. So half of that is $50,000. $50,000 is safe for the community spouse right off the top. That's how you calculate this, the CSRA. Countable resources, divide that in two. All right. So what are these resources? So we've got non-countable resources. Those are exempt resources, resources that are, not included as part of a Medicaid application. You have to show them, these assets, but they're not countable. So the big one obviously is the home. The home is an exempt resource, especially, that's especially important for the community spouse. If it's a married couple, the home's exempt. You don't have to worry about being, you don't have to worry about having to sell your home to pay for your spouse's care. Also, a vehicle is exempt. And if a couple has two vehicles, it's the most expensive vehicle. That's the one that's exempt, and that's the one that I would tell the clients to count as a non-countable resource. Then you have a pre-need funeral plan. They have to be irrevocable, but one for the spouse and one for the community spouse, those are both exempt. And of course, you got your household good and personal possessions. That includes jewelry. That includes collectibles that you have. That's all exempt. Then we have, this is a more recent development, an IRA. So this is like a 401k or a typical IRA that is in payout status. So if you are receiving RMDs, the required minimum distributions from an IRA, or you're just receiving a constant flow of money from your IRA, that could be annually, it could be monthly, it could be quarterly, what have you, that's exempt. But I can explain why that's kind of problematic in the next slide. But that's on its face, that's exempt. Countable resources, that's everything else. So that's bank accounts, that's IRAs that aren't in payout status, that's investment accounts, stocks, life insurance policies. If life insurance policies have a cash value, those are countable resources. So, like I said about IRAs, it becomes problematic because Ohio has this program called Medicaid Estate Recovery. That means that assets that are owned at death are paid back to the state, in its simplest phrasing there. So that would include that exempt home that a person would have and that IRA that was in payout status. Those could be, if they're exempt, that person's on Medicaid and they're receiving Medicaid services, and then that person passes away. Medicaid can then put a lien on that house to the amount of Medicaid benefits that they've given that person. So that means that if that family member, that child that received the house at that person's death, if they would sell the house, they would have to pay off that lien just like any other mortgage. So that would eat up a lot of the equity. And for Medicaid purposes, although the house is exempt, we have to start thinking about what we need to do with that house. It's not an immediate concern, but it's, according to our plan that we have to, put together, I always like to think of the house being a countable resource because of this Medicaid estate recovery at this person's death. The IRA, that we think is exempt, we probably have to do something about that. We probably would have to liquidate it if the person's single, or we have to annuitize it if the person's married. And I'll get into annuities in a second here. But we have to do something with this IRA eventually. Maybe not during the month of application because it is exempt, but maybe we should, think about liquidating it, or we should do an annuity for the spouse's benefit. So this Medicaid compliant annuity, in that simple example that I gave in the very beginning here about we've got $100,000 in the bank, and let's just imagine that's all the married couple has. All right, I said that $50,000 of that is exempt because of the community spouse resource allowance. And then you asked me, Ethan, what do you do with the other $50,000? Do we have to spend that on the nursing home before we can apply? That's what the nursing home would tell you, because they would receive the private pay rate, which is much more advantageous for them than the Medicaid rate. So they would say, yeah, pay us for the next 5 months. We'll deplete that $50,000, and then you're Medicaid qualified. Then we'll apply for Medicaid. Where what I would do is I would apply right away for Medicaid, even though we have $100,000, because during that month that we apply, we would do this Medicaid compliant annuity for the community spouse's benefit. We take an accountable asset like this $50,000, we convert it, we pay for an annuity that will immediately pay every month for the community spouse's benefit. And you're telling me, well, how is this possible? How can you protect this extra $50,000? Well, income is treated differently than assets for a married couple. So income paid to that individual is their income. So income paid to the spouse that needs Medicaid, they have to use that income for their care at the nursing home. It's called a patient liability. Income paid to the married spouse is their income. They can do whatever they want with that money. They can set that money aside, pay for their things. So what we're doing here is we're converting the countable asset of $50,000, converting it to an annuity, and that will pay a monthly stream of income to that spouse. And voila, you just saved $100,000 and you got your spouse on Medicaid that they need at the nursing home. There's certain requirements to this annuity, but this is the basics of it. It needs to be immediately paid. It needs to be a constant stream. The terms can be, anywhere from 2 months to the Medicaid table of how long this person is going to live. It's what's Medicaid says that what they say is their life expectancy table. So there's certain requirements to it, but the gist of this is, hey, it's going to be paid out to the spouse for a certain number of months or years. So then we get into improper transfers, and this is what everyone's worried about, is this 5-year look back period. I get this, clients confuse this 5-year look back period all the time. And what this 5-year look back period means is when you apply for Medicaid, that month that you apply, Medicaid, which is Job and Family Services, they look back at your assets of the last 5 years to determine if any improper transfers were made. An improper transfer is essentially a gift that you've given someone or something like a charity for unequal value in return. So a $10,000 gift to a child or a $10,000 gift to the church, that would be an improper transfer. So what does that mean in part of a Medicaid application? Well, for every $7,453 that you gift, that is 1 month of Medicaid that they won't pay for. So that means that if you've gifted, you either have to get that gift returned, or you have to private pay for that monthly time period that you gifted. So a $74,000 gift, that's about 10 months of Medicaid that you have to privately pay if you don't have the funds to get those funds returned to you. But if you see here, Medicaid doesn't say if you gift, we will not pay you Medicaid. You don't qualify for Medicaid. What they say is if you gift, we'll penalize you. So they're saying we will eventually pay for your Medicaid after this penalty period. So we use gifting as part of our planning. When it's what I call crisis planning, what practitioners call crisis planning, and that means a spouse has a fall or a single person has a fall. Let's talk about a single person because that's where these improper transfers really come into play. A single person has a fall and they can't go back home. They are they're bedridden, but their mind is healthy. It's just their body is weak, and they can't go back home, so they have to go to a nursing home. And they've got this $100,000 in the bank. So what are they going to do? They have to spend this money, or they say, well, no, I want to, instead of paying this to the nursing home, I want to apply for Medicaid and I want to save as much of this money as possible. And what I tell clients at that time is, okay, we can save about half of the assets, half of this $100,000 that you have, because if we gift, we have to account for that gift. You can gift $50,000, but this other $50,000, we have to set that aside in order to pay for that penalty period that we've just incurred. So a $50,000 gift, that's about 6 or 7 months at the nursing home that they have to pay for. If you divide $50,000 by 7453, you get about 6.5 months, give or take. I don't know the exact to the decimal point, but I'm pretty sure that's about accurate. But so you're saying, well, Ethan, I've got to pay the nursing home for the next 6.5 months. Well, that's right. That's why you have the other $50,000 that we set aside in a special trust, and you have your income coming in. So, crisis planning. Yeah, you do have to pay the nursing home, but you don't have to pay the nursing home everything. You can save a big portion of your assets. You can gift those away to your family members or to charities, whoever you want, instead of it all going to the nursing home. And I'm giving, obviously, this is just the basics, and this everyone's different because the income is different. The cost of private pay at each facility is different. So there's wrinkles to all of this, and there's nuances to all of this, but this is for general talk, that would be the plan. So how do we prepare for Medicaid? If people are worried about I want to make sure that we can do this type of planning, Ethan, or I want to protect as much of the assets as we can. Well, the simplest thing you can do is just have the proper power of attorney in place and other, estate planning documents in place. A run-of-the-mill financial durable general power of attorney that you get off the internet or you get from an attorney that doesn't practice elder law won't have the powers that you need in it. Not every power of attorney is the same, because the powers of attorney that I create, we have the powers to gift. We have the powers to create trusts. We have the powers to do a Medicaid plan, essentially. You can put protections in a power of attorney to protect against nefarious doings of your agent. But you need these powers in the power of attorney to do this type of planning. And then another important topic is, irrevocable trust planning, where I tell clients the ideal, scenario is I have an elderly couple coming in to see me. They're in their, mid to late 70s. And their health is, fairly good. They have some assets, and they want to make sure that, hey, our parents developed dementia in their 80s, or they've had health problems, and we just don't want that. We saw what happened to our parents. We want to make sure that it doesn't happen to us. That's where irrevocable trusts come into play, where you can do an intentional gift to an irrevocable trust and wait 5 years. Medicaid does not see that transfer to the irrevocable trust if that person needs to apply for Medicaid. So, that 5-year look back period is only 5 years. So if you transfer your assets to an irrevocable trust, and then 6 years later, you develop dementia and you need to go to the nursing home, well, you just saved the assets that you put in this irrevocable trust. You saved your house. You don't have to worry about the house because the house is already in this irrevocable trust. You don't have to worry about the money that you put in this trust because it's already set aside. The issue that a lot of people have, which is a very viable issue, it makes sense, is you lose all control, possession, ownership of these assets that you put in this irrevocable trust. More than likely, you're putting your child as the trustee of this trust, and the children are the beneficiaries of this trust. Essentially, you're making a completed gift of you're advancing your estate to this irrevocable trust. So I never advise clients to put their whole estate plan, their whole assets in this irrevocable trust, because that'd just be silly. You need money, you need your, assets to live on because those are yours. But, maybe you can transfer the house. Maybe you can transfer some money there. And if that gives you peace of mind, then that's great. You just protected that asset. The problem is, don't need Medicaid in the next 5 years, because if you do, then you have to undo that gift. You have to undo this trust, because that would be an improper transfer that they see in that 5-year look back period. So I've got, what time is it here? All right, 11:39. I'm going to go through these examples quickly, but I thought examples would be nice, so you can see these rules that I said, in action. So we have a single person, and they have a house that's worth $200,000. They've got $100,000 in bank accounts. They've got $100,000 in an IRA that's in payout status, and they have a $10,000 whole life insurance policy, and they have one vehicle. So this person applying for Medicaid, if they're not worried about, saving money and protecting money, they could get on Medicaid after they pay $100,000 from their bank accounts to the nursing home after, over a year period. Let's say that $100,000 is gone. Well, the house is exempt. This IRA is in payout status. They're getting a monthly check, or they're getting a yearly check from the IRA. That's exempt. This whole life insurance policy, well, if you assign that, irrevocably assign that to a funeral home, then that funeral contract, that funeral plan is exempt, and the vehicle's exempt. So after a year, you could save, you could, apply for Medicaid, and you could get on Medicaid. Then the problem is, if you die and you have these assets, well, Medicaid will then, put a lien on the house. You'll have to pay out the IRA to Medicaid, and the vehicle would have to be sold and paid to Medicaid as well, to the amount of Medicaid benefits. So how do we do a plan to protect these assets? Well, what I would do is I would count the house as part of, accountable resource. Maybe we have to sell it, or maybe we have to put it, use it as part of the gift. Let's use it as part of the gift. Let's assign the whole life insurance policy like we did before to the funeral home. And let's use the IRA and the bank accounts, let's put that money aside in a pooled Medicaid payback trust, because guess what? We're going to gift the house to a child or to the children, multiple children. The $200,000 house would be gifted. The $200,000 that we have in money here would be put aside in this trust to pay for that $200,000 gift. We sell the vehicle, maybe we can sell that, we can use it for various things. But here, in this example, we just saved $200,000 by doing a gift of the house, and then the bank, the liquid assets then would be used to pay for their care during that would be a pretty substantial penalty period. If you did take that $7,453 divided by 200,000, you probably get about a 3-year penalty period. But that's the kind of plan that would work. You'd save half of your assets at that time. A married couple, then, this is, we've got the $100,000 in the bank, $100,000 in IRA, and a house worth $100,000 and 3 vehicles. What I would do to save these assets for the community spouse is we don't have to worry about the house. The house is exempt. We'll have to retitle the house. We'll have to get that transferred over to the community spouse's name. But I'm not worried about that. That's fine. The IRA, it's exempt because it's in payout status, but we want to get that out of the community spouse's name, or the institutionalized spouse's name, the person that needs Medicaid. So I'm going to do a Medicaid compliant annuity of that $100,000. So that way the community spouse gets a monthly check from this annuity. The $100,000, half of that's exempt. So $50,000 would stay, and the other $50,000, I do another annuity for the community spouse. The highest vehicle, that's exempt. We have to do something about these other 2 vehicles. We either have to sell them, or we just include that as part of the $50,000. So this $50,000 that's exempt for the community spouse, that's any number of assets, could include that $50,000, cash, vehicles, what have you. But there's nuances to this, but at the end of the day, virtually everything could be, saved for the community spouse and this married couple. So that's what I've got for you. I know I talked a lot there, and I apologize for that. And I gave you guys a lot of information. But at the end of the day, if you have a married couple, you can save virtually everything for the community spouse, virtually everything. You have to rearrange some assets, and it's difficult because you have to provide all this evidence to Job and Family Services, but it's possible. At the end of the day, it's possible. You can save virtually everything. For a single applicant, you can save, at least half of the assets. You could probably save a little bit more depending on the income that person receives and the cost of care that you have to consider. But at the end of the day, Medicaid and the nursing home is not going to take all of that person's assets. Most, if not all, if we're talking about a married couple, of those assets will be protected. That's what you should come away with this. And if you have issues, then you need to talk to an elder law attorney. That way they can, put together a plan to protect most, if not all, of the assets at that time. So with that being said, I can open the floor to questions. You can put it in the chat. You can put it into the you can raise your or talk, whatever, what have you. I see that I have got some questions in the chat box already. So let me take a look here. So I have one person saying, how does Medicaid affect the beneficiary if there's one parent living and they still own their home? So how does Medicaid affect the beneficiary if one parent living and they still own their home? So I don't know what you mean by the beneficiary. Jennifer, can you
Yeah, I'll explain a little bit
Yeah.
more. So my question is related to, so my father just passed away.
Okay.
And so we started, when he became sick, we started going down the route of the assisted living facilities, the pricing, private pay, because my dad was a government employee.
Mhm.
So I started learning about Medicaid, and my mom was discussing these options. And so we gathered that information. Unfortunately, my dad went into hospital, never recovered. He passed away in August. And so now my mom is a widow. Of course, they had a survivorship deed. She has the home, and she has a few accounts as well. And so of course, I have power of attorney over my mom. I am the only child. And with these accounts, some accounts are in her name, some accounts, we are joint owners of the accounts. So with all that being said, I'm looking forward to the future now. If my mom gets sick, and I understand you have to draw down all assets, or, you have to draw down, like you said, to a certain amount for Medicaid.
Yeah.
As a beneficiary, and the power of attorney over my mother, how do I plan ahead? So we don't completely lose everything my dad worked so hard for that now has been passed down to my mom. And so my question is just about generational wealth. So with Medicaid, I mean, with my mom, she's a widow, single person.
Yeah, now she's a single person.
Yes, we're drawing down these assets. If I need to now draw down everything and go to Medicaid, it's how I take it is that everything my dad worked hard for now goes to nursing homes and goes to Medicaid. So is there a way to not let that happen and not have any tax implications? Because there are penalties and fees, and like you said, with gifting, there's so much that goes into that. So as a beneficiary, how do I protect my dad's assets that now my mom has? That's essentially the question.
Right. So the number one, even though you're joint with your mom on those accounts, those are your mom's accounts. So Medicaid counts that as totally hers,
Exactly.
not half. Just wanted to make that point first.
Mhm.
And, depending on what your mom's health is now, you could do a 5-year gift and wait plan where you could gift now, and hopefully your mom doesn't need Medicaid in the next 5 years. That's one option. And then if your mom does need Medicaid, like I said, not everything needs to be spent on your mom's care. You can save, a big portion of the assets. If we're talking about crisis planning, you can save over 50% of the assets. Not everything will be spent on her care. But if the way to save the majority is doing both plans, if she's really able to, doing a 5-year gift and wait plan. And then if she needs Medicaid after that 5 years, do crisis planning at that time, where you can gift about half of the assets. The other half would have to be used on her care. Doing that, you would save a huge percentage of the assets. Not everything is foolproof, because, something will need to be spent on her care. The only exception is if you have a disabled child, or a disabled grandchild for that matter, someone that is receiving Social Security on its, that's the on its face, that any gifts to a disabled child is exempt. So someone could have $1 million in the bank, gift everything to their disabled child, and they could get on Medicaid that month. So some of the rules are advantageous, especially with the disabled community, which is a great thing. It's a good thing. And so you don't hear that too often with the government. But at the end of the day, not everything will be spent on that person's care with a disabled child or a non-disabled child beneficiary.
Okay.
All right, so we've got another question here about, responsibilities of the power of attorney and when choosing the POA. How important is it to have someone living in the same city? There are some issues. When my brother died recently in Columbus, I was back and forth, but there was not there day to day. A former girlfriend took over the POA role. That's awful. And locked family out of matters relating to my brother. Yeah. I have a social worker on staff. She's our care coordinator. And in the social worker, circle, they think of powers of attorney as a license to steal. There's some truth to that, because a power of attorney unchecked could, take things over. And you hear about that all the time. You hear that in the news more and more, where a person's $900,000 retirement account was wiped clean by the power of attorney. So the power of attorney does not have to be in the same city. They don't have to be in the same state, for that matter. Nowadays, everything can be done, electronically, virtually, or most things can be done that way. In my powers of attorney, if there are questions about, nefarious family members or friends of the person creating the power of attorney, I put in protections in the power of attorney, oversight provisions. There's people that can get access to the power of attorney and block the power of attorney if possible. There's a consenting party provision that if they want to do something drastic, like gift money, that they have to get approval from that consenting party. So, not, like I said before, not all powers of attorney are the same, and the run-of-the-mill power of attorney won't have these provisions. So that's something that you need to talk to the elder law attorney about getting that in place. And yeah, powers of attorney, they're a great thing, but they could also be a terrible thing. I got another question here. How can you protect rental properties in a jointly owned LLC? One person's elderly, the other is just a typical middle-aged person, doesn't need Medicaid. Well, that one half ownership in the LLC, that is, accountable resource. So you have to do something about that LLC, that one half interest, because that would be, payable back to Medicaid, or that person can't even qualify for Medicaid, unless they do some sort of Medicaid plan. One of the exceptions, though, for Medicaid is a business interest. So, a business interest could be exempt, but there's certain parameters that have to go around. So, really, you just need. There is a way to protect that business interest if they have an ongoing. They use that money for ongoing, purposes. But that's just something that you need to talk over with an elder law attorney to, get it down to, the letter of the. Another question here. My sister is taking care of our mother, and someone told her she can get paid now for it. How would that affect my mom's home? Should we gift her home to get out of my mom's name? So that's an excellent, point, which I haven't. I discussed in my PowerPoint. There is a caregiving exception where a caregiving child exception, I should say. If a child is living at the home and that child is preventing that person from going to the nursing home, with their care, the house can be then transferred to the caregiving child as part of the Medicaid application. So Medicaid is rewarding this child for caring for their parent and keeping them out of that nursing home for at least 2 years. There's certain, steps that you have to take. You have to have a doctor's note, level of care assessment completed, about this person's condition and what the child is providing. And you have to have documentation in place proving that the child is living there, that the child is providing care, and what that care all involves. So there's certain things that you have to do the home would then be gifted. And by the way, you could have a caregiving contract in place with the child and the parent, where the parent is paying the child, a monthly amount of money. So you're kind of double dipping, where you're getting money because you're providing a service, but you're legally, you're not gifting money either, because you're providing a service. So you're legally transferring money to a child. And if you ever need Medicaid, the house could be transferred as well to that child. So you're legally double dipping in that regard. But that's an excellent point. I didn't want to really put it in the PowerPoint, but that's one of the exceptions to the house and money. So another question that just popped up: what if mom is living with her daughter and not in mom's house? Well, that's, they can still do that caregiving agreement, and the mom can be paying that daughter that monthly stipend or monthly amount, not stipend. It could be a stipend, but the monthly amount to that daughter. But the house, I mean, it's not in mom's name, so that doesn't really apply with the transferring the house. Any other questions?
I don't have a question. I just have a comment.
Sure.
Many of you know, when I was becoming a member of this organization, the Kent area chapter of the Links, I was losing one of my relatives, who was a caregiver for another relative, my mother's sister, who was diagnosed with with dementia. And I will say that Hickman and Lauder, Litterbach and Welch, specifically Ethan, they were extreme. I don't know what I would have done, honestly. I had never been a caregiver for anyone, as I had to assume responsibility for my aunt. And I really didn't know what Medicaid and Medicare, what any of that was going to look like, until I was able to speak with Ethan at this law firm, this elder care law firm. These are topics that we're talking about that none of us like to discuss, but it is essential. We all know this, that, you have to plan for the future, and you have to plan for, for death. I have to say that. And so I did see that we have maybe one or two more questions in the chat box, but I'm glad that we are revisiting this. My mother is still living, and these are things that, I will certainly have to circle back around to. But please ask the questions, because this is valuable information that we're receiving. But I did see a couple of questions just pop up.
Someone just asked, what is the cost of a consultation with my firm? I charge, for me personally, I charge $300 for a consultation. But if you decide to, retain me, then I add that cost to the fee, to the overall fee. So it just joins in with the retainer then. But if you wanted to, talk to me for an hour and say, I just want to get information and maybe I'll decide later, then yeah, it's just a $300 fee for that.
Very good. Well, Ethan, I think that answers our questions that are in the chat.
Okay.
We thank you for your time. We thank you for the information. And thank you for helping the Kent area chapter of the Links bring some information forward. And thank you all for attending the session today. Again, the slides will be provided and a copy of the video will be provided as well. Thank you.
All right. Well, thank you, everyone. Thank you, Gabrielle. Thank you, Tammy, for inviting me. And hey, enjoy the weather while it lasts, because we live in Northeast Ohio and we know what's going to happen here.
Oh, for sure, for sure. Yes, and thank you. I would like to say a special thank you to our Kent area chapter of Links. I know some of them are popping off this call. You know, this was a Saturday morning that I know people had other meetings and things, I mean, including myself. But special thank you to Delaney West, one of our newest members, who was able to help with creating a flyer that we sent out to our guests. So Delaney, I just wanted to say a special thank you. And also for our facet chairs who are on the call, Roxia Boykin and Kendra Prier and Allison Ivy. I think Allison popped off, but I really appreciate you guys representing our facet. So Ethan, can't thank you enough, and I will be in touch.
All right. Thank you, Tammy.
Have a good day.
Bye-bye, everyone.
Bye-bye.